Member for Mississauga-Arundel.
Thank you, Mr. Speaker. I stand before you today to debate the motion presented by the Conservatives to extend the sunset clauses of two extraordinary powers, preventative arrests and investigative hearings. These two clauses were part of the Anti-Terrorism Act that was implemented by the Liberal government just over 5 years ago in the aftermath of the September 11 terrorist attacks. The government of the day acted quickly in response to the urgent needs of modernizing our security regimes and laws. During the legislative process, the government of the day consulted with Canadians and examined various options. The challenge was, and continues to be, how to find the right balance between introducing new security tools and yet still maintain the protection of fundamental civil liberties and human rights. After carefully examining and considering numerous and valuable thoughts and ideas, the government made a bargain with Canadians. The new law would proceed with introducing these two powerful tools, but place them on a probation period. These tools would be given a 5-year trial period, and if during that period it emerges that their benefit outweighed their risk, lawmakers would then have the opportunity to renew them. Otherwise, the default option was that those clauses would sunset at the end of that period. That compromise was concluded after consulting lawmakers, legal experts, law enforcement agencies, and community leaders. Now that the 5-year trial period has ended, we parliamentarians have to decide. Do we honor the original compromise and let those clauses sunset? Or do we feel that those tools have been proven necessary and choose to change our original plans and vote to extend that period? Mr. Speaker, this House has a serious choice to make. A House of Commons subcommittee has studied this choice. The findings of that subcommittee recognized the power of those tools and offered 10 recommendations. The recommendation stated that if the government and the House want to extend those clauses, they need to accompany them with some tweaking and adjustment. The Conservative government chose to ignore the holistic approach the subcommittee chose to adopt, and instead of accompanying this motion with legislation that took into account the necessary changes, they are asking us to ignore our duties and maintain the status quo. Mr. Speaker, over the last 5 years, we've learned so much. We've seen mistakes where innocent people were caught in the web of confusion and handicapped judicial system, like in the case of Mr. Maher Arar. We've seen our courts push back on some security legislations, and we've witnessed that our ordinary legal system is capable and has the necessary tools to protect Canadians. Canadians are proud of our law enforcement agencies. We are confident in our legal system and courts, and we are proud in our values and principles. As lawmakers, we must always examine our decisions carefully, responsibly, and dispassionately. Once again, Mr. Speaker, I'm proud to demonstrate a clear contrast between the Liberal Party and the Conservative Party. The Conservatives, at the time of passing the Anti-Terrorism Act, wanted the Liberal government to implement blunt tools that could risk our civil liberties, while the Liberals were careful to maintain an appropriate balance between providing the right security tools and protecting our fundamental liberties. Here's another example. Now the Liberals, after finishing the trial period and realizing that these tools didn't turn out to be needed, are ready to restore our traditional laws. The Conservatives want to enshrine these extraordinary tools without even offering any type of adjustment or balance. Canadians are familiar with the tendencies of this Conservative Party, whether it's in their approach to dealing with crime, refugees, minorities, or Aboriginal people. They start with the premise that you are guilty until you prove your innocence. They assume the worst in people and fearmonger so they can justify imposing blunt and harsh instruments or legislation. Mr. Speaker, I call on all of my colleagues in this House to join me in restoring the needed balance in our judicial system. Our legal system is an international symbol of fairness and equality. We must work to strengthen it, not paralyze it. The essential need for checks and balance may at times appear cumbersome, but it is the wise approach. It is the outcome of hundreds of years of social and legal evolution. And it is designed to protect the citizens and at the same time provide our law enforcement agencies with the support they need. 5 years have passed. We now know that those two tools have not been used and were not needed. In the meantime, our law enforcement agencies have been able to operate effectively. So why should we leave those extraordinary measures on our legislative books? Why risk any potential abuse or errors in the future? Our judicial system is fundamentally built on balanced dynamic of checks and balances and oversight. This tricky balance must be respected and preserved. I would argue that our existing laws already provide the necessary tools, and now that we have just finished our 5-year probation period and realized that these two clauses are not needed, we must take a sober second look and fulfill the initial intent of the legislation. Let's allow these two clauses to sunset and reinforce the traditional role of our judiciary. Thank you very much, Mr. Speaker.